Hello and welcome to another view from Mayor Brown. This sits alongside our regular podcast and is an occasional series of interviews with those involved in the changes going on in employment law. The podcast is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to a special podcast today. We're talking about Turkish employment law and employment law issues of interest to international employers in particular with operations in Turkey. And I'm genuinely delighted to be joined by Irmak Direk, who is a founder partner at the Istanbul law firm of DAB Law. Irmak, delighted to have you on the podcast. And first of all, let's start with the obvious question. Tell us a little bit about DAB Law, the firm that you founded.
Okay, thank you first of all for the opportunity. We recently, as three founding partners, established a new law firm, a DAB law firm, which is located in Istanbul, Turkey. We are a boutique law firm with three founding partners, and we all come from reputable international law firms, and we do our best to assist our current clients in all kinds of legal matters. We are basically specialized in labor, immigration law, corporate and commercial law, banking, finance, capital markets law, and also IP law. As DAB, we do our best to assist our international clients and, of course, Turkish companies as well in all regulatory and legal matters.
Sounds fantastic. And can I just say, on behalf of those of us who are part of much larger organisations, I'm incredibly impressed about setting up a law firm. I think it's a really, really amazing thing to do.
Thank you very much. Thank you.
So let's start with the beginning of the employment relationship. And I'm an international employer, and I'm looking to perhaps second someone in to work in Turkey, or I'm looking to transfer an existing employee from another operation into Turkey. Tell me about the general procedures for getting residence and work permits.
Okay. As you know, Turkey is an attractive country for foreign investment. Therefore, we come across with many immigration issues with respect to our foreign clients. First of all, of course, the foreigners are obliged to obtain a work permit before they start to work dependently or independently in Turkey. Such work permit applications can be made either abroad or in Turkey. For instance, for a work permit from abroad, an application shall be made by the foreigner to the Turkish diplomatic representatives of Turkey in the foreigner's country of origin. Such Turkish diplomatic representatives of Turkey shall forward such application to the Ministry of Labour and Social Security in Turkey, and then the Ministry shall lead the process regarding the work permit application electronically. But the foreigners holding a valid residence permit, at least for a period of 6 months, can directly apply to the ministry in Turkey, and the ministry shall conclude the work permit applications in due form within 30 days as of the date of the application. In the law, it is stated that the period is 3 months, but in practice, usually the ministry grants the work permits within a month.
That's worth knowing. So it's quicker than the official process. It's
yes.
About a month.
Yes.
All right, thank you.
And there are some types of the work permits available for the foreigners. First of them is the definite period of time work permit, and another one is indefinite period of time, and the third type is the independent work permits. Usually, the foreign employees prefer, of course, indefinite period of time work permits, and also there are some requirements, notification requirements for the employer companies with respect to the work permits of their employees. So also the employers should always follow the procedures in order to notify and inform the ministry and the relevant authorities in this respect.
Okay. In general terms, if I can just ask a question. If I was speaking to, say, a British company, and they're saying they'd like to get a residence work permit, they'd like to send an employee out to Turkey, is it a sort of process that's easy and you can have confidence that you will get the permit, or is it deliberately designed to be quite difficult to get permission?
Actually, it depends on the employee and the employer. The characteristics of the employer is very important here, because the ministry takes into consideration some criteria. The nature of the work is important, because you have to convince the ministry that employment of a foreigner is required. I mean, you are employing a foreigner instead of a Turkish citizen, and you have to convince the ministry in this respect. And therefore, the academic background of the employee in question is significant as well. And they also look for the contribution of the workplace to the national economy. So the employer company shall be strong. And there are some evaluation criteria in this respect. For instance, the ministry looks at the paid up capital of the company, and it has to be minimum 1,000 Turkish liras. Or, for instance, the gross sales of such employer company has to be minimum 8,000 Turkish liras. So the company in question should be strong. And also, there's an important criteria. If you are employing one foreign employee, then as an employer, you have to employ 5 Turkish employees for each of the foreigner.
Gosh.
Yes.
And that's a requirement, is it?
Yes,
because
because
we don't have anything like that. I mean, like your country, the UK and others are looking at restricting inward-bound employees, and why can't you employ someone from within the European Union? But the concept, there's a 1 for 5, one for 5,
yes.
is novel.
It is very different from Europe, and
Yes.
usually the clients have problems with that criteria.
Yes.
If you are employing 2 foreigners, that makes 10 Turkish employees. So if you are establishing a new company and you want to assign your general manager in Turkey and some other employees, foreign employees, then that will be a problematic criteria.
Yes, I can see that. Okay, sorry, I cut across you, but that was brilliant. I couldn't resist asking about that. Yes.
I know. So these are the basic criteria, and of course the law stipulates some other criteria as well. But these paid up capital and 1 to 5 rule are very significant when you are making a work permit application.
I can see that they would be the things that would strike an international employer with no prior experience as being the most different.
Yes.
Well, all right. Let's move the relationship along, if I can say that. Let's move the relationship along to talk about the employment relationship. Let's assume that we've got our work permit and our the residence and work permit.
Yes.
In what sense does Turkish employment does a Turkish employment contract perhaps look a little different to the sort of contract that a British employer would expect?
Yes. First of all, I have to say that it is very imperative that the transactions and contracts which are made between Turkish bodies should be in Turkish language. This is a validity condition. So if it is a Turkish company executing an employment contract with Turkish employees, it has to be in Turkish language in addition to any other language. So that's a validity condition, which is very important for the international companies.
Can I ask what happens if you don't do it in Turkey? Is the contract invalid, or
yes, it is considered as invalid.
Wow.
If it is not in Turkish language, and this is also applicable for any other contracts as well.
I'd come across it where termination documents in some European countries have to be in the local language,
Yes.
and if you dismiss someone but you've got the wrong law for dismissing letter,
Yes.
then the dismissal isn't valid.
Yes.
So in general terms, I'm jumping ahead slightly to the
Yes.
ending of the relationship. Is it the same principle?
It is the same. Yes, if it is a Turkish company and if it is executed with another Turkish legal body, I mean a company or an individual, it has to be in Turkish language.
But if it's an international company employing a Turkish employee,
Yes, and then it can be in any other language.
fine. Okay, fine. So you're right. We're talking about the general provisions applying to employment relationships.
Our labor code also does not draw any specific distinction between blue-collar and white-collar employees and between senior management and other regular employees. And when an employee is employed by a company, it has to be registered. I mean, the employee has to be registered at the Social Security institution. This is a very important thing under our laws. And the mandatory Social Security system provides some benefits like unemployment pay, work accident pay, maternity pay, etc. For instance, if you are employing a general manager as a company, that person has to be also registered in the Social Security Authority and added to the company's payroll. and that manager is also an employee under our laws. However, a member of the board of directors is not an employee for the purpose of our labor code. But if you are assigning that board member as a manager of the company, for instance, then again that person becomes an employee by our labor code. This is a very, actually, again, popular question from our foreigner clients, because they are usually assigning their board members as managers, but sometimes they are not. So if the labor code is applicable or not is a very significant issue in this respect.
Again, we don't have the same sort of provisions that if you're an employee, you're an employee regardless of status, and directors can be employees and tea ladies can be employees. So it's slightly different.
If it's the only board member, then labor code will not be applicable. Our Turkish commercial code will be applicable.
Can I just ask a question? One of the big questions that we are often asked about is the distinction between being an employee and being self-employed. And so that if I'm a consultant providing services to a company, the employment laws may not apply to me, or they may apply to me even if the contract says they don't, because the law applies if certain factors are met. Do you have the same distinction in Turkey between consultants who are not covered by the employment code and employees who are?
Yes, there are some, again, evaluation criteria with respect to that issue, and the independent contractors should have a separate tax ID and social security registration, a different type social security registration by himself. And also, if that contractor is only working for a specific company in that workplace, and only dependent to that company, then he may be considered as an employee in case of a lawsuit.
Despite being registered as a self-employed person, the law can say, in reality, you're an employee. Just the same with us.
Yes, and also the supervision is important. If he is under the supervision of that company, dependently and in that workplace, then he may be considered as an employee.
Yes. We have a similar thing about being in business on your own account. If I'm running my own business, I might be just working for one person, but I'm actually running a business as a consultant, then I'm self-employed. But if in reality I'm totally dependent on the customer and I'm not really running a business and I'm a disguised employee, then the courts will see through the documents.
Exactly. Also, the courts in Turkey really tend to decide in favor of the employees. So this is also a very popular issue in Turkey with respect to the contractors.
Okay.
When I come to the validity condition of an employment contract, I have to say that if it is for a year and over, then it should be concluded in writing. This is a validity condition again. But the parties may regulate the employment contract in any kind. What I mean is that it can be definite or indefinite term. It can be full-time or part-time with a probationary period or without a probationary period. And if you are inserting a probationary period into an employment contract, it has to be maximum 2 months. It can only be increased by a collective bargaining agreement to 4 months. So this is an important issue as well.
Can I ask about collective bargaining agreements? Because you mentioned them, and throughout Europe, you have countries like the UK where the individual contract of employment is absolutely the key document. You have countries like Italy, for example, where the contract of employment is relatively insignificant because collective bargaining agreements regulate by law certain aspects of the employment relationship. So that if I am a lawyer, for example, my contract of employment might be very short, but there's a collective bargaining agreement that applies to all lawyers in Italy, and there may be a collective bargaining agreement for my region as well, as I understand it. Do collective bargaining agreements play a big part in Turkish employment law? Are they only in certain types of job? In other words, is the contract of employment, the document itself, the primary document? Or are collective bargaining agreements very important and you have to look at them as well for most employees?
First of all, trade unions are not very common in Turkey. It usually depends on the industry. For instance, in metal industry or coal industry, the trade unions are very common. And if there is a trade union in a workplace, then these collective bargaining agreements will replace the employment contract. So you have to check the collective bargaining agreement and the provisions under that contract and the benefits provided to the employees, and that will be the main contract actually. So it is very significant if a workplace has a trade union.
I understand. Okay. Anything else on the general provisions of the employment relationship?
I can basically say that the working hours are maximum 45 hours per week, but overtime work is possible, and if the overtime work exceeds 45 hours in a week, then it will be considered as overtime work, and there are some other, of course, additional payments and conditions thereof. And there are some statutory annual leaves under our laws. Again, it depends on the term of service. For instance, I'm just giving one example here. If an employee is working for a period of 1 year to 5 years, then the annual leave for that employee will be 14 days for a year. And it increases as per the length of service of the employee. And the annual leave durations constitute a minimum, but they may be increased by employment contracts, and then they will be taken into consideration. And lastly, I want to note that if there is a material change in a working condition of an employee, this is very important. You have to get, if it is an adverse material change, you have to get the prior written consent of the employee before making that change. And that prior written consent should be given within 6 business days after the notification of the change. Otherwise, such material change will not be binding on the employee in question.
Interesting. I can see how that would be something that would catch a lot of employers out, because the slightly fluid nature of the way things work in England. Sometimes there are some changes where you can impose a change, and if the employee hasn't complained within a certain period, then the change is taken to be binding.
Okay.
It's very different. Very, very different.
Yes.
Okay. One of the things that we do a lot of, and which causes a lot of comment from employers, are provisions around non-competition and confidentiality.
Yes.
What's the situation in Turkey with those provisions?
Yes, these topics are also very actually popular topics among our foreign clients. First of all, of course, an employment contract imposes an obligation on the employee to act honestly and in compliance with the principle of fidelity. And such fidelity obligation can be extended by an employment contract. Of course, as per such principle of fidelity, the employee is expected to acknowledge and protect the interests of the employer, keep undisclosed his commercial secrets, and etc. In case of a breach of the employee, it can be a valid cause for termination of the employment contract for the employer. And of course, the employee may be liable to compensate the losses that have been incurred by the employer. And also, when we are preparing the employment contracts of an employee, we are inserting provisions, and these provisions usually are for indefinite terms, and therefore the employee is liable to stay confidential even though after the termination. And it is also possible to put penalty clauses into the employment contracts, and you can force these provisions by getting a court decision in this respect.
So penalty clauses do work in Turkey, and that's interesting because in England it's very difficult to make it for confidentiality. It's very difficult to make that work. Is it common? Do most contracts, if they have a confidentiality clause, have a penalty clause, or is it an option to put a penalty clause in? Sometimes companies say we would rather have the damages claim and not the penalty clause.
Actually, since you have to get a court decision in order to get the penalty fee from the employee, the employer is liable before the court for proving its damages, and it's sometimes only limited to the damages, but sometimes you can get the compensation. It depends on the specific case, actually.
Okay. So non-competition covenants. How do they work in Turkey, and what tend to be the protections?
These post-termination prevention of competition by the employee is regulated by the employment contracts through a non-competition clause or by executing separate non-competition agreement. It depends on the employer actually, and our code of obligations imposes some conditions that must be satisfied for a non-competition clause to be valid. First, there should be a risk that the employee may cause considerable loss to the employers. This is the first condition, and the second condition is with respect to their term. Again, our code of obligations state that such clauses cannot exceed 2 years unless there are any special circumstances. But these terms also depend on the relevant market. If it is a very active sector like banking sector, it is usually in market practice limited to 6 months. It depends on the sector usually. And also another condition is in relation to the geographical application of the non-competition provision. It shouldn't be very broad like Turkey. It should state a city or a region like Istanbul in order to be valid. Yes.
That's interesting because English covenants, they can be worldwide. Mm-hmm. You have to show you need worldwide protection, mm-hmm. but it would be very unusual to find a covenant that prohibited competition in London, mm-hmm. let's say. Yeah. So that's yes. Again that's a significant yes. difference.
The court would probably consider as well invalid in case you state Turkey there, because the employee then does not have any chance to work anywhere, and it's limiting the employee's rights as per the courts. So, and the fourth condition is actually in relation to the area of the work. It should be a related area. It has to be the direct competitive area. Yes. So that's another condition. And in case you put a penalty fee again under that non-competition provision, the employee may pay that penalty in order to be free in that respect. It is possible. If the employee pays that amount, then you cannot enforce that non-competition provision.
So do employers prefer, very difficult question to answer generally, I know, but mm-hmm. do employers prefer to put the penalty clause in and think, well, at least I'll get some money mm-hmm. if the employee goes off and competes? Or do employers prefer to have no penalty provision but just the covenant so that they can stop the employee working? Mm-hmm. Actually, maybe I ought to ask a question mm-hmm. first. Under English law, you can get an order from the court that stops the employee breaking the restricted covenant.
Exactly, in Turkey.
And it's the same in Turkey.
Yeah, but you have to get the court decision in order to
in order to understand. Now, do employers tend to want to have the court order and no penalty clause, or do they want to say, well, I'll take the money?
Actually, the important thing for the company is, of course, to stop the employee.
Yes.
But these penalty clauses make the employees, of course, afraid from the situation.
Yes.
So they are usually preferring to put some penalty clauses, even though they know that they may not get that amount from the courts.
And sometimes, presumably, that penalty clause is paid by the new employer if they're wanting to recruit someone and it would be a breach of the restrictive covenant. Mm-hmm. The new employer might say, well, I really want to hire you. It's going to cost me, it's going to cost the employee, this much to join me. I will pay.
Yes, that may be the case, but also there is a non-solicitation provision under our laws. So we do not recommend our clients to make that payments to the employees. At least it should not be approved by the former employer.
Right. Okay. Okay. Fine.
Also, one last note about the non-competition provisions. If the employer has terminated the agreement on invalid and unjustifiable grounds, then no lawsuit can be filed against the employee for the breach of the non-competition clause.
That's very similar to ours. If you dismiss someone in breach of contract, mm-hmm. Then the restrictive covenants mm-hmm. won't apply. Fascinating. Fascinating. Okay, talk about the transfer of a business, because that's the other area where we do a lot, and I imagine you see a lot of work as well, because employment rights where a business is transferring are often quite challenging to work out what the employees' rights are. So talk us through that.
Yes, first type is actually in the transfer of business is an asset sale. Of course, it is very popular in big M&A deals, so it's a very big major issue for the employees as well. In the event that the workplace is partially or fully transferred to another legal body on the basis of a legal transaction, then the employment contracts that exist at that workplace will transfer to the transferee together with all their employment rights and obligations. This is explicitly stated under Article 6 of the Labour Code. So this is a mandatory provision.
And that sounds very similar to the Acquired Rights Directive and the Transfer of Undertakings, which is the English version of the Acquired Rights Directive.
Yes, we don't have such a regulation, but it's
the same outcome.
Under the Labour Code,
right.
Exactly.
Okay.
And in respect of the rights for which the service term of the employee is taken into consideration, the transferee is obliged to take into consideration the date that the employee started to work for the transferor.
I'm with you. So continuous service, the period of service then is continuous. Yes, very, very similar there.
And the transferor and the transferee are jointly responsible for the debts accrued prior to the transfer and due on the transfer. However, there is a limitation here. The liability of the transferor is limited to 2 years following the date of transfer. And also, such an asset sale cannot be considered as a just cause for termination for the transferee or for the transferor.
Under English law, just picking up on that last point, under English law, that if the transferee can show that it has too many staff, it can make staff redundant. Organisational change.
Yes,
justifies.
actually we have that.
You have that too.
Too many staffs may be considered as a valid ground. What I'm trying to say is that if there is a financial and technological reason or organizational restructuring, and if you can really prove that, then it's possible to terminate an employment contract. But you have to be very careful in this respect because there are many lawsuits filed.
I can understand. The other aspect of the Acquired Rights Directive in Europe, you have enhanced protection for employees. They automatically transfer with the business to the new owner. And there's a collective consultation period that is usually mandatory before the transfer goes through. So the transferor needs to say to its employees, I am planning on transferring you to the new company. These are the new company's plans for you. Please tell me what you think about the plans for the employees, any changes to the workforce, and you get a period of advance warning in which the transferor's employees can ask questions, can raise matters with the transferor, and the idea is the transferor will go to the potential transferee and say they're asking for this information and that. Is there anything like that under Turkish law?
Not really. I mean, there are no notification requirements and there is no consultation requirements for the employees. However, as I explained, if you are making a material change on these working conditions, you have to get written consents of the employees within 6 business days. This is the case. However, other than that, there is no notification or consultation requirement.
Okay, thank you. That's very clear.
For the share sales, actually, any changes in the shareholding structure of a company will not affect the status of the employees as long as the identity of the company remains the same. So there is, again, no information or consultation requirement for the employees, and there is no written consent requirements either. However, if there is, a material adverse change in the working conditions, the prior written consent is required. And lastly, we have a concept of transfer of the employees, and it is different from the asset sale and the share sale, of course.
You have a third way of transferring employees?
Yes, and it is only in relation to transferring of the sole employees. There are no other asset transfers, and it's only transferring the employees of a workplace. In that case, the written consent of the employee would be required because only the employees are transferring without any assets. And in that case, we usually recommend to our clients to execute three-party agreements between the transferee, the transferor, and the employee. And under our laws, it is mandatory again to transfer the employees with all their rights, like notice and all seniority-related rights and bonus premiums, etc. And we also state that provision under the transfer agreements explicitly in order to be clear for the employees as well.
If you would use that third option, if you weren't transferring assets, you're just transferring the employees.
Exactly.
So, for example, within a group, you might say we want our employees to all be employed in one service company, and so you take the employees out of business companies and put them into the service company and have all your employment.
Exactly.
Fine.
Yes.
Okay. Good.
So we are calling that transfer of employment contracts, actually.
I'm with you.
It is explicitly stated like that under the Code of Obligations.
Okay. So let's say we've recruited someone, we've given them a contract, we've got the work permits, and we haven't transferred them to another business, but we've had enough of them and we're going to sack them. So what are the rules in Turkey around the termination of employment, especially the ones that would be of surprise or different to the sort of things that international employers might know about?
For the termination of employment, of course, it's a very sensitive and significant issue for each jurisdiction. The first stage of termination is sending a termination notice to the other party under our laws, and it should be that termination notice shall be made in an express and clear manner, and it should be in writing. This is very significant. And the termination of employment has two different types: termination with notice periods or immediate termination with payment, the notice pay. And there are minimum notice periods under our labor code, which shall be again determined as per the length of employment of the employee. I'm just giving one example. If the employee is employed for a period between 6 and 18 months, then the applicable notice period is 4 weeks, and it changes as per the term of service. And of course, during the notice pay, the rights and liabilities of the parties shall fully remain in force. As I explained, the indefinite term employment contracts may be terminated in accordance with the terms under the law. However, if such termination right is abused by the employers, then the employee may claim some compensation from the employers. Actually, this is applicable for the employees who are not protected by the job security provisions. And I will briefly explain the job security provisions to you. But before that, I want to state the amount of that abuse of termination right compensation amount. It is explicitly stated under the law, and it is the 3 times of the salary corresponding to the applicable notice period of the employee.
So it's 3 times the applicable notice period.
Salary. Yes.
Right.
Yes.
Okay.
Yes. And when I say the notice period salary, it also includes the other benefits, not only purely.
Because under English law, you can have a provision that allows you to just pay the salary.
Yes.
And a lump sum. Yes.
Yes.
Yes. You've been there. You know that.
Yes,
Yes.
I know that.
Right.
It's not the same.
Not the same. Right. So in that example you gave of someone between 6 and 18 months service, they have the right to 4 weeks.
Exactly.
And so under these provisions, it could be 12 weeks. They'll get 3 times the...
Yes,
yes.
exactly.
Good.
Exactly.
Okay.
And on the other hand, if the job security provision is applicable in a workplace, then a valid ground for termination is required. But if it is not protected by job security provisions, then you can terminate without a valid ground. But if it's an abuse of termination rights, the employee may file a lawsuit.
Right.
But if there is a job security provision applicable, then you have to have a valid ground for termination. And the criteria for the job security provision is that the company should employ 30 or more employees. The employee in question shall have an indefinite term employment contract and at least 6 months of experience in that workplace. And also, he shouldn't have an employer representative position.
Right.
In that case, the job security provision will be applicable. And in case of termination, the employee may file a lawsuit for re-employment. And if the company does not want to re-employ that employee, then a compensation amount up to 12 months' salary would be in question. So this is a
Right.
high salary for many
Yes.
other jurisdictions.
What are the sort of grounds that justify, if there's a job security provision in place? You mentioned that there were some additional grounds you had to show.
Yes.
What sort of additional grounds are we talking about?
For instance, if you are terminating the employment due to the performance of the employee,
Yes,
you have to get the defense of the employee before termination.
right.
And first, for instance, you have to inform him in writing and get his written defense, and then give him some time for proving a better performance, and
Yes,
of course giving him some time in order to develop. So you have to prove that you as an employer did everything that you can do before terminating the employment.
I understand. And so presumably it's conduct, so if they're dishonest or they steal, conduct is a reason.
Okay, now we are coming to that.
I'm rushing ahead.
No.
I'm going too fast.
No, actually, under our laws, there are some material reasons
Right.
explicitly stated that make the continuation of the employment relationship very difficult, and these are all explicitly stated. And in these cases, the employee or the employer make the termination immediately, without paying any notice pay and without waiting for the notice periods. And these are, I'm just stating the employer's right of immediate termination. For instance, the health grounds and events contrary to the ethical rules and goodwill, and occurrence of a compelling event in a workplace that makes the work stop. These are employees' right of immediate terminations. There are some others as well. I just want to mention that if there's an event contrary to the ethical rule and the goodwill, then the employer also can terminate the employment contract without paying any severance pay. So in these cases, there is no notice pay, since it's an immediate termination right, and also there is no severance pay. I'm just giving some examples which are stated under the law. Employee harassing the employer or any other employee of the company, employee not acting in good faith and honesty, and breaching the employer's faith, committing theft, disclosing the professional secrets of the employer. These are considered as events contrary to the ethical rules, and you can terminate an employment relationship without paying any severance pay in these cases.
You mentioned harassment and bullying. Can I just ask a question?
Sure.
Discrimination rules.
Mm-hmm.
Are there strong rules in Turkey prohibiting discrimination? Are they? What are the grounds? I suspect it's probably a subject in its own right. But
Yes.
what are the sort of grounds? Because in England, for example, you can't discriminate on the grounds of sex, race, religion.
Mm-hmm. Yes, it's the same in Turkey actually.
Right.
We have that discrimination prohibition under our labor code, and also other laws like civil code, like
Yes.
criminal code, and even the constitution. So there should not be any discrimination in any area. But of course, it's also applicable for the workplaces as well. We don't have any specific regulation for discrimination, but they are always prohibited under different laws like labor code, civil code, and etc., as I explained.
Okay, fascinating.
And lastly, when we come to the consequences of termination of employment, the employers should pay a remuneration for dismissal to the employees. As I said, first one is the notice pay, but there are some exceptions, as I explained, under our labor code. But other than that, the notice pay shall be paid to the employee in case of termination. And the second one is severance pay. For the severance pay, the employee has to be employed for at least 1 year in that company. It's an important criteria. And also, for the severance payment, I want to explain the calculation of the severance payments shortly. The severance payment is the last wage of the employee multiplied by the years of work of the employee in that company. So if the employee is working for 6 years for that company, we have to multiply the last wage of the employee with 6 years. However, there is a maximum statutory threshold that has been fixed for the severance payment, and as per such rule, the severance payment to be made to an employee for each full year may not exceed 3,500 Turkish liras. This amount changes every year, but this is the current one right now. So there is a maximum threshold. This is very important when you are calculating the severance payment.
I understand.
And also the third termination payment is the accrued but unused annual leave payments. Even though the employee resigns, you have to pay that accrued annual leave to the employee during the termination. Another type of the compensation, the fourth one, is the contractual compensation. If you have any provision under the employment contract with respect to a compensation, then you should also pay that amount during the termination to the employee. And lastly, the workplace practice. If the provision of such benefits to an employee during a termination has become customary through permanent practice, then as an employer you have to follow that permanent practice and you have to pay that amount to the employee during termination. Otherwise, the employee shall have the right to file a lawsuit to ask for that workplace practice termination payment. And you have to prove that this is different from the other terminations in order not to pay that workplace practice termination. And these are the basic termination compensations regulated under our laws.
It's fascinating how much is the same and how much is different and where the differences come. Thank you. That was really, really interesting. And I learned a lot just listening to you talking and answering questions. So thank you for allowing me to interrupt you. Now, we always try and end with a personal question. So I know that outside work, to the extent you have an outside work, being a founder partner of the DAB law firm, outside work, the challenge must be to find time to have any time outside work.
Yes.
What do you do in terms of, relaxation, hobbies, whatever, outside work? What's your favourite pastime?
Actually, as per the things I enjoy outside work, traveling is one of them.
Right.
Yes, it's very exciting for me to learning about the new cultures and meeting with new people. So I try to visit to different countries as I have a chance and time for that.
So I'm going to ask you. I'm going to ask you two questions. Your favourite country that you visited, and
Spain.
the favourite country. Wrong answer. I think you meant England, but all right. So we're going to come back to that, and then the favourite country you'd like to visit that you've not yet been to. So favourite country is Spain. Why Spain?
Spain. Yes. Actually, Spain, especially Barcelona.
Yes.
Because it's a big city, and also it's like since it's a Mediterranean city,
Yes.
you can just rest on the beach and swim, and also have the benefits of a big city
Yes.
in every way.
Yes.
So I think, and also I love the food. Spanish food is my
Yes,
favorite.
yes.
So I like the weather there. So
It's perfect.
and also the people there. They are all.
It has a lot of advantages.
Yes, they are very warm and they are really helpful people. And I sometimes think that they are similar to Turkish people in that way. So I also love Greece and Italy as well. And of course UK.
Oh, thank you. We got there eventually. Take a hint.
But the food is very important for me. That's
Sure.
why I think Spain is my favorite and Italy is also my favorite.
Good. What about a country that you haven't visited that you'd like to visit?
I think it's Thailand.
All right. I've been to
Yes.
Thailand. I went 20 years ago, so it's a long time back. But
good.
I thoroughly enjoyed it. Why Thailand? What is it about Thailand?
Actually, I traveled to India for several times, and in India, I saw that the cities have different characteristics and unique styles. Like Bombay is different, and there are some other cities which have beaches like Kerala, Goa, and etc. So it's very nice to see that cities are very different.
Yes.
And in Thailand, I think, I'm more focused on the beaches and the summer vacation, I think.
Fine, I
But
see.
when we are going there during the winter of Turkey,
Yes.
it is summer there, and also I'm very excited about food again.
Yes.
So I'm planning to visit Thailand soon, hopefully next
Hopefully.
year. Yeah.
Good. In that mythical time, that time off that you get from running a law firm.
Yes.
Well, Matt, listen, thank you. That genuinely has been really interesting. Thank you so much for coming
You're
and
welcome.
talking to us. And what we'll do is we'll post a link to your email address. So if anyone has got any questions on anything that's been said in this podcast, or they want to get in contact about business matters, they'll have your contact
I
details.
would be happy to assist. Yes, thank you.
Fantastic. Okay, thanks so much.
Thank you.
So, that concludes this podcast. We hope that you find it and others in this special Another View series helpful. If you have any comments or questions, please email Nick at nrobertson@mayorbrown.com. This podcast is an overview of the cases and law, and how the law will apply in any particular case will depend on the individual circumstances. Listeners should seek legal advice if any of the matters discussed are relevant to a specific issue or concern. Thanks for listening.